Welcome, and thank you for tuning in to this Ed Days presentation, an update on classified employees' rights and recent legal developments. I'm Hannah Foote, CSEA Staff Travel and Event Coordinator, and I'm honored to introduce your presenter for this course, CSEA's Chief Legal Counsel, Andy Kahn. Andy, thank you so much for taking the time to talk through these important developments for our members.
Thank you very much, Hannah. I look forward to spending the next 45 minutes or so talking about everything except COVID. If you're like me, you're tired of hearing about COVID developments, so I'm going to talk about legal developments not involving safety from the virus. And they come from 4 different sources, and I've presented you here a table of contents of what I'm going to cover today. The sources of the legal developments are, of course, the legislature, which has increased the minimum wage, shortened probationary periods for classified staff, expanded your rights under 2 important anti-discrimination laws, SIFRA and FEHA, and finally, it's changed the law on personnel commissions picking their own attorneys. The appellate courts have done several things that impact school employees in the last year or so. They've clarified when summer unemployment benefits will be available. They've clarified on when probationary employees who are out on disability leave are entitled to disability accommodation. They've made very clear that in California, employees are entitled to be paid for every minute worked if the employer can track the time. The California Supreme Court has also made clear that employees waiting in lines at their work site or otherwise doing things that are under their employer's control but aren't technically work are still entitled to be paid for all this time. The court has also addressed the California rule about pension rights and addressed disability pensions for employees who are facing discipline. The courts of appeals have been very helpful to us in giving local voters the right to approve school taxes by a simple majority, 50% plus 1, not what everyone thought before now, which was that you needed 2/3. Other courts have said that paid leave may be required for reservists who return to active duty in the military. And finally, there's been several court developments under the Public Records Act, which has been interpreted to allow more public access, with some limitations that I'll go through in more detail shortly. PERB has been another important source of new employee rights for classified employees. It's made clear that employees cannot be forced to answer employer questions about conduct by another employee that is being represented by the union in a disciplinary proceeding. PERB's made clear that a union does not waive its right to bargain unilateral changes by not seeking bargaining in the past over similar prior changes. The right to union representation has been held by PERB to extend to employees asked to give a written statement or just to submit to a search or a drug test. And finally, PERB has been very good about aggressively interpreting the scope of mandatory bargaining to include most subcontracting decisions and new employee monitoring systems. Finally, safety agencies have done a number of new things for our members in the last few years, including regulating exposure to wildfire smoke, to outdoor heat, and to violence by students and others in the workplace. So let's dig into those in more detail, starting with new legislation. Most importantly, the minimum wage has been increased recently and is set to go up again to hit $15 an hour next January. It's $1 less for smaller employers, those under 25 employees. And then on January 1st of 2023, that minimum wage will just automatically increase with inflation. With some very limited exceptions, it will not be pegged to a particular dollar amount by the legislature. Recently, family leave has been expanded by the legislature. Just this past year, SIFRA, the California Family Rights Act, which used to have a right to 12 weeks of unpaid leave to take care of a sick child or parent or spouse, that scope has been expanded to include caring for grandchildren, grandparents, and siblings as well. CIFRA also has been expanded to help employees out who are assisting other family members with various needs because they are entering into active military service. And there's a long list of ways in which leave can be taken to assist folks entering active military duty. And very importantly, for those of you who work for small employers, the minimum employer size used to be 50 employees. It's dropped down to 5. So practically every employer now is covered by CIFRA. Also protected by the legislature has been union activists through bills that provided broader leave rights, that banned employer discouragement of union support, and finally that limited employer communications about the right to belong to a union. So first, leave rights. We have some very good ed code provisions, but they've been supplemented now by SB 1085 that amended the government code to set a broad right to take a leave to serve as a steward or as a union officer. In this case, under this particular statute, with the union reimbursing the employer for the cost. Other statutes don't require that reimbursement. Management communications have been limited by SB 866, which says that before an employer can go out and communicate with multiple employees about their rights not to belong to the union, the employer must review a draft of that communication with the union. And if the parties can't agree on wording, the union can insist on the employer sending out a rebuttal at the same time, and may even be able to force the employer into fact-finding. As a result, most school districts are not engaged in mass communications with their employees any longer about their rights not to belong. They simply say, go talk to CSCA if you don't want to belong. Now, similarly, the legislature stepped in when it saw that public employers had been discouraging union support and passed a broadly worded statute that prohibits employers from discouraging or deterring union support. And that means more than what it was in the old days, where PERB only said employers had to avoid threats or bribes. Thanks to this new law, other kinds of conduct that's intended to discourage union support are also prohibited. And finally, as many of you know, AB 119 in 2017 expanded unions' rights to new employee orientations and to obtain prompt new hire information from employers. Discrimination in other arenas has also been addressed through recent legislative action. FEHA, the Fair Employment and Housing Act, our main state anti-discrimination law, used to require that charges be filed just 1 year after the conduct. Now that's been increased way out to 3 years, so much longer statute of limitations. FEHA has been clarified to provide that natural hairstyles are also a form of protected conduct. FEHA has been amended in 2 different ways to try to limit the practice that arose prior to the Me Too movement of employers overreaching with settlements and, for example, banning employees from ever seeking rehire. Now, the legislature has said that at most an employee can acknowledge that an employer has non-discriminatory reasons not to rehire them, but the agreement cannot prohibit the employee from applying for a rehire at a later date. Settlements also now cannot include a waiver of rights under FEHA unless there is some sort of claim pending against the employer that may involve FEHA rights. For example, either a grievance or something through the internal employer procedure to address discrimination, or more formally pending in front of a state agency or court. But absent a pending claim, the employer can't get the employee to waive their rights in exchange for other consideration. Finally, in the arena of discrimination, the legislature has stepped in and required employers to provide private rooms for mothers to lactate and provide a right to paid breaks for that time. Closer to home in the school districts, in the merit systems, we used to have a problem with personnel commissions using the same lawyers as were representing the school districts. And so it appeared to be a conflict of interest. But the commissions were required by the prior statute to use the school district's law firm. And the poor commissions in this situation weren't sure they were getting unbiased advice. Now, thanks to a bill advanced by CSEA, AB 2234, a majority of commissioners are allowed to vote to select independent counsel if they don't want to use the school district's firm. Also, in the school district specific statutes that have been added to the code in recent years, AB 1353 shortened the probationary period for non-merit K through 12 schools from 1 year down to the shorter of 6 months or 130 paid days. So now it's the same, both merit and non-merit. Now, there is a small exception for those collective bargaining agreements that were in effect January 1, 2020 and continue to be in effect now. The loophole in that law that was left by the California Federation of Teachers when they lobbied for it was the community college districts. And now our governmental relations department is trying to get the same law extended to those districts through the pending bill AB 275. Legislature has also made some significant changes in school operations that impact classified employees. The start times, starting in July 1 of 2022, middle schools are going to have to start at 8 o'clock or later, and high schools 8:30 a.m. or later, except for quote unquote rural schools, which was left undefined in this statute. There is a new SB 328 pending this year that will provide a clear definition of rural schools so everyone knows who's exempt from this law. The other operational change addressed by the legislature were the training requirements for security guards. And thanks to CSEA's support, this was extended to part-timers in 2019. Now, many other decisions coming out of the courts will have impacts on school employees. Most importantly, I would say, is the issue of summer unemployment benefits. The California Supreme Court in the United Educators of San Francisco case last year said that it was no longer permissible to award unemployment benefits for broken promises by school districts of providing summer work. So that changed the prior law. Now, obviously, if an employer makes a promise that you rely on, you may have a contract remedy, but you don't have a remedy of unemployment benefits. The court also did something interesting with summer programs and said that if they are so robust as to resemble regular school programs, an employee is entitled to unemployment if they don't get rehired for that strong summer program. So this, unfortunately, is a very hard situation for our members because it's set by federal law. And so this court decision would take an act of Congress to avoid. So the general rule will continue to be that it's very hard if you're hired for 9 or 10 months to collect unemployment if you've been given notice that you're likely to be rehired in the fall. Now, in the area of wage hour laws, the California Supreme Court has been very aggressive in protecting employees. It's held that courts are not free to ignore a few minutes a day. In the federal court system, there's case law that forgives unpaid time of less than 7 minutes a day. The courts call it de minimis, which is lawyerese for too small to matter. And the California Supreme Court has instead said that when you're a low-paid worker, every minute matters. So if the employer system allows precise tracking of time, for example, as in the Starbucks case in front of the court, the employee had to log into an electronic system to get in and out of the building, that time should all be paid, even if it's only a few minutes per day. In the Apple case, the California Supreme Court again rejected federal case law and said that time spent on bag searches would be compensable work, because while you're waiting there in line to have your bag searched, you're under the control of the employer. And similar reasoning would apply to the Ed Code and to other kinds of time where you're doing something other than your regular work, such as waiting or preparing or cleaning up at the end of the day. In the field of disability accommodation, the courts have said that probationary employees who have to go on leave of absence due to a disability are entitled to an extension of their probationary period. The district cannot let them go just because they lack work experience, if that lack of experience was caused by them being disabled and needing to go out on leave. The district has two choices. It either has to extend the probationary period, or just, if it wants to hold to the original 6-month probationary period, it just has to grant these employees permanent status based on what it knows about the employee. Now, when it comes to disability, CalPERS, of course, provides for enhanced disability benefits, but there is a major obstacle to employees collecting those benefits in the case law. CalPERS holds that if you're facing discipline, you're going to be barred from collecting these disability benefits, with only limited exceptions. And this was the Martinez case from the Court of Appeals, where an employee entered into a settlement agreeing to resign in the face of pending discipline. And even though the employer consented to this employee receiving disability benefits, CalPERS said, we're not bound by private agreements. You've made this employee ineligible for rehire, and our statutes limit these disability benefits to those employees who theoretically can be rehired, those who might recover from their disability and then return to working for the same employer. Now, the court does acknowledge there are exceptions to this general rule when the disability is the cause of the misconduct that's leading to the discipline, or where the employee is so obviously disabled that had they gotten their application into CalPERS earlier, it would have to have been granted. And the court offered the example as if someone lost a limb. So important law to be aware of if you want to collect CalPERS disability benefits. Another clarification in the law by the Court of Appeals is that CalPERS cannot deny disability benefits just because an employee is physically capable of working somewhere other than their usual location if their employer is the cause of them not being allowed to work at that other location. So in the McCormick case, the court said it doesn't matter that the employee might have been able to do the work elsewhere if the employer is the reason that they aren't being allowed to do that work and they're therefore unable to receive their salary. So the moral of the story is CalPERS and the employers are not going to be able to blame the victim of an ADA violation who's been refused a reasonable accommodation of a changed work location. Very importantly, on pensions, we had a decision come down from the California Supreme Court about the so-called California rule. And this is a rule that limits the legislature in its ability to amend pension laws to the detriment of current employees. California rule was traditionally understood as saying that if you cut the pension rights of existing employees, you have to provide them a compensating new advantage. You can't just lower their overall benefit. If you cut one part of their benefit, you've got to provide compensation elsewhere. That was the traditional understanding of the California rule. However, the Supreme Court reinterpreted this rule to say that a legislative body can close loopholes that provided an unfair, anticipated a benefit to employees. And there you had two provisions of law that allowed final vacation payouts to be included in the definition of someone's compensation for 1 year. And so you obviously could end up in a pension spiking situation. So the court said that the legislature can step in and stop pension spiking without having to provide a compensating advantage. But contrary to the fears of many in the labor movement, the court did not overrule the California rule. Court, as I mentioned at the outset, did something important for school funding. The courts have said that Prop 13 does not require 2/3 voter approval to a local initiative measure to increase taxes. It only applies that 2/3 requirement to measures that are placed on the ballot by elected officials. And so we've had 3 different courts of appeal in California reach this holding that the electorate isn't limited in its flexibility to pass tax increases for schools. Now, these decisions come from intermediate courts of appeal, so this issue might end up in front of the California Supreme Court, and it might decide the issue differently. But these are very well-reasoned decisions which point out that when Prop 13 was passed, it was sold to the voters as limiting what the politicians can do. It was never sold to the voters as suggesting it was limiting what future voters could do through the initiative power. There have been recent developments in the Public Records Act that will impact public employees. First, on the subject of employee disciplinary notices. Can the public get a copy of a disciplinary notice you've been issued? The Chino case, the court held that districts have to deny PRA requests for copies of discipline if the employee misconduct did not impact the public interest or if the allegation against the employee was found to be baseless. But otherwise, if the allegations are shown serious and to impact the public interest, the district is required by this law to turn over copies of disciplinary notices. In the particular case in Chino, the court said that the fact that some coach was behaving rudely towards the kids on the team didn't impact the public interest as it wasn't sexual or racial in nature, and so did not require the district to turn over copies of this discipline. In the San Jose case, the PRA was extended, very importantly, to the personal devices of public officials and public employees if they are discussing public business using their own phone, laptop, etc. So beware of using your own personal equipment unless you're ready to deal with having to comply with a Public Records Act request and potentially having your device searched by someone who works for the district, or the district asking you to provide a declaration under penalty of perjury that you have searched your own device and are turning over all the emails that have to do with the public business that's the subject of the PRA request. The third important PRA decision was about my friends who work in the management bar. The court in the LA County case held that the PRA requires districts to reveal the amount spent on legal fees by public employers once a matter is concluded, but not while a case is still pending. And the details of the legal work done in the case don't have to be provided to the public, but the amounts, including the overall amounts and the hourly rates, are subject to disclosure under this decision. Now, of course, you've all heard about the Janus decision. The courts of appeals have addressed efforts by the Right to Work Foundation and similar organizations to try to expand those rights beyond the Janus holding. The Janus holding is simply that the First Amendment prohibits public employers from forcing their employees to pay dues or service fees under pain of losing their jobs. The Objectors to union dues have tried arguing, well, that also means that membership applications that require a long-term dues commitment aren't enforceable. And the courts have uniformly said, no, 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 Janus does not go that far. And it has upheld the enforceability of long-term dues commitments, even if those, like CSEA's application, provide for a one-year dues commitment and will roll over for another year if not canceled during a window period. The court noted that gyms and insurance companies and cable companies all have similar agreements, but the First Amendment has never been construed to limit their right to enforce commitments to pay money. I mentioned at the outset that important developments have occurred for employees who are in the reserve and are called up to duty. And one court in the Seventh Circuit, which is in Illinois, has construed this federal law as requiring paid leave for active duty if an employer is providing paid leave in situations of jury duty or illness, which of course every California school employer will be doing because they're required by state law to do so. Now, this decision is very controversial. The management bar is very upset by it because of the potential cost. And so the issue is likely to end up in the U.S. Supreme Court. However, employers, while they're waiting for a Supreme Court decision, really are at great risk if they refuse to provide such leave, because employees will be entitled to their legal fees, which will often dwarf the amount of pay involved. So a well-advised school district, I think, is now going to give strong consideration to providing paid leave when reservists need to return to active duty. PERB has been a good source of new rights and clarifying existing rights in recent years. Speech protections have increased through decisions like that in Chula Vista, where PERB narrowed the standard for when an employer can get away with disciplining employees for making statements criticizing management. If those statements are about negotiable issues, wages, hours, working conditions, or if those statements are made criticizing union leaders, the employer can't discipline unless it proves the employees made false statements of fact, and they did so knowing these statements were false. And that's an extremely hard bar for employers to meet. A lot of times what happens is employees utter negative opinions, and no matter how nasty those are, PERB has said that employers can't use discipline to address that. The remedy for unpleasant speech, PERB basically is held, is for the employer to engage in its own speech. Now, PERB has gone much further than the law that exists in the private sector with this latest decision in City of Commerce about employer investigations. PERB has held that if an employee is being represented by a union in an upcoming hearing about discipline, management cannot force other employees to engage in investigatory interviews. Instead, the employer has to wait till they're questioned at the hearing. And the rationale for that is at that time, they will be represented by the union during that proceeding. And basically, to question them before that is to inquire into what the union's theory of the case is going to be. Now, an employer can seek to have employees voluntarily be interviewed prior to the hearing, but it has to provide them a specified set of disclosures about their right to refuse to go forward with the interview and provide them assurances as to their job security. They can't be punished for declining. PERB has addressed the use of district email for union activities and held that is presumptively within an employee's rights, just like doing union activities out on the sidewalks outside the workplace. The employer has to meet a very high standard of proving special circumstances to limit such speech. So that's a big change, because it used to be enough for employers to just be consistent in banning all work non-emails. Now, employers must affirmatively accommodate employees' labor speech on its email systems. Now, pushing this right, though, will have major risks for the employees. For example, there's nothing stopping the employer from reading the emails that go out on its system. So I urge you, before you resort to using work email for all sorts of union activities, to talk to your LRR. Also, remember, PERB can't overrule the Ed Code, and the Ed Code still bans political activity using work email. PERB has recognized an additional source of release time when there is difficult bargaining going on. PERB has held that the right to reasonable release time in the existing statute includes the prep time, particularly if the parties are close to impasse and the union is facing very complex and difficult proposals. And in the case before it, involving Oroville Union High School District, PERB found that 1 day off for prep time was a reasonable union request because the employer's wage proposal had a complicated formula with various financial contingencies, and the parties were close to impasse. And PERB's reasoning here is interesting. And basically they said, if we don't recognize a right to preparation time, then what ends up happening is that each party ends up going into a long caucus in order to do their preparation. And then that wastes both parties' times. So it'd be far more efficient to just come right out and say, let's let the union do its preparation before it meets with the employer, instead of using caucus time for that purpose. PERB has been very good on the subject of subcontracting, and that it's a negotiable subject, not only the effects, but also the decision. And in County of Kern, PERB held that the decision to subcontract is negotiable not only when it takes away unit work, but if it involves a brand new function, but one that's similar to existing unit work. So that's very helpful to CSEA, as we've seen new statutes being adopted in the COVID era to try to deal with learning loss. Those are, if not identical to existing unit work, they're certainly similar functions that we believe fall within this Kern County decision. Waivers of bargaining rights have been held to be quite limited by PERB in recent years. In a case involving CSEA and the Modoc County Office of Education, PERB agreed with us that we did not waive our right to bargain in voluntary reductions in hours because we did not have contract language that showed clearly the parties had bargained this precise topic, nor was there contract language which clearly waived our bargaining right. And the standard PERB uses is called clear and unmistakable. That's what a waiver has to meet before it will be recognized by PERB. Another case involving CSEA involved the San Bernardino Community College District not bargaining before it installed GPS trackers on security officers' patrol vehicles. And PERB said that the ALJ had been correct in ruling that management was required to first give notice to the union and provide an opportunity to bargain before it could install these monitoring devices. This is similar to other PERB holdings that notice and bargaining are required before an employer installs video cameras or any other surveillance device. PERB in this San Bernardino case also held that an employer's demand to an employee to give a written statement triggered their right to consult a union representative just as much as if they wanted to question the employee in a meeting where everyone presumably knows there's a right under the Weingarten decision to have union representation. PERB said employers can't get around the Weingarten right by just handing the employee a piece of paper saying, give me a statement. PERB reasoned that the union rep could be valuable in helping the employee decide what should and shouldn't be included in that statement. Now, Weingarten rights were also addressed in a Department of Corrections case, which held that the right to union representation extends to investigations where you're not asking for the employee's version of events, you're instead asking for them to submit to a drug test or submit to a search of their body or their locker or their personal property. And the PERB reason that unions can counsel employees on what to do when faced with those demands and on the adverse consequences of an employee refusing to consent, because this is an arena where the employer can infer you've got something to hide if you refuse to consent. Now, finally, I've mentioned at the outset, safety and health agencies have stepped in and improved classified employee rights. In 2019, we saw a new wildfire smoke regulation come out of Cal-OSHA. And sadly, I'm afraid we're headed into another summer where this regulation is going to be relevant. If the air quality index hits 151 or higher, the employer is required to take a number of affirmative actions to protect employees if those employees will spend over 1 hour per shift exposed to outside air. The employer must monitor the air quality index and notify employees when this trigger is met so that they can remember to wear respirators, and the employer is required to provide the N95 respirator that's needed in this kind of situation. The employer doesn't have to make employees wear them unless the AQI gets much higher, gets over 500. And the employer has to do more than just masks. They have to try engineering controls such as air filtering and administrative controls such as moving work inside, reducing the amount of intensity involved in physical work, and increasing the amount of breaks where employees can get into air-conditioned air. The regulations of Cal-OSHA have been extended through an appeals board decision to some unexpected folks. Right now, those outdoor heat regulations will apply to those who drive a bus or other vehicle if the vehicle doesn't have working air conditioning. PERB held that this is just as bad as working outside of the vehicle, and therefore all the requirements apply, whereby the employer must provide water, must provide shade, must discuss with employees emergency procedures, and train employees on how to recognize heat illness. And finally, violence is unfortunately a concern in our workplace and has been addressed through both administrative agency action and the California Legislature. The Legislature in 2019 has expanded the ability of employers to deal with unsafe individuals in the workforce. It used to be that only a family member or a law enforcement officer could file a petition that sought to restrain an individual who had threatened violence from continuing to possess a gun. AB 61 expanded standing to bring such an action to include employers or co-workers or a broad range of school employees who have been witness to and subject to threats from someone who possesses a gun. The federal OSHA has an appeals commission that has rendered an important decision that protects school employees from violent students. In Integra Health Management, this commission held that if an employer is on notice that clients or students are prone to violent acts, the employer has to take reasonable action to protect the employee. It's not sufficient for the employer to blame the violence on the client or blame the violence on the student. The employer has to step up and attempt to take the employee out of harm's way. So that concludes my quick run through of recent cases impacting classified employee rights. More details and links to these decisions is posted up on the CSCA website. And I want to thank you all for your attention. Take care.